Hi, and welcome back to Chapter 6 in your Commercial Transactions curriculum. Today we're going to be talking about capacity, or the ability to contract. But before we jump in, I'm going to do a brief review. Remember, at this point we're going through the elements of a contract. All of these elements have to be present in order for us to end up with a legally binding agreement, which is the goal. So far we've talked about offer, acceptance, consideration, and mutual consent. And the next element in line is capacity. So let's jump in and talk about that. By the end of this chapter, you should be able to understand the meaning and definition of legal capacity. You should be able to determine when contracts are enforceable against a minor, establish when intoxicated persons have the ability to contract or the capacity to contract, define the concept of ratification and its application, and resolve when contracts are void or voidable when the issue of capacity is raised. So as you move through your analysis of contracts, you need to understand that understanding or agreeing to the terms of a contract is not sufficient to bind the parties. An additional element must be present, and that's capacity. Most individuals who enter into contracts have capacity, and usually it's not an issue. But the occasion does arise when parties to a contract lack the legal capacity necessary to bind themselves to a contract. Some people who fall into this category are minors, people under the age of 18, the mentally handicapped, people who have been declared legally insane, intoxicated persons, drug persons, and people who just generally can't understand the contents of the agreement that they're supposed to be agreeing to. So let's define legal capacity. The requisite capacity to enter into a contract requires that you be an adult under the law, that you be legally sane and mentally healthy, that you be sober and not addicted to drugs, that you be a legal resident of the United States, and that you not be a felon in some cases. We're going to talk about each one of these and whether or not it creates a void or avoidable contract. The first one we'll talk about is a minor's contractual capacity, and it's the easiest one to understand and sometimes the hardest one to understand the application of. Hopefully we'll get through that in just a few minutes here. Now, state statutes determine when a person legally becomes an adult. In most cases, the age of majority when somebody becomes an adult is the age of 18. Sometimes it's as high as 21. Prior to reaching that age of majority, we refer to people as minors. And the law sometimes refers to them that way because they lack the capacity to create binding contracts. So here's the first time when we see the difference between void and voidable contracts. Minors have no capacity to contract, and therefore they create voidable contracts. They're not automatically void, but they are voidable, which means that the minor can decide whether or not they want to continue to abide by the terms of the contract. They can also avoid a contract by disaffirming a contract, and disaffirmance is a method of rejecting a contract and therefore canceling it. So basically a minor can disaffirm a contract prior to the time when they reach majority and for a reasonable time thereafter. Now interestingly, this voidability doesn't apply to both sides. So if you are a minor and you enter into a contract, you have the power of voidability rests with you. You have the power to disaffirm that contract. On the other hand, if you're an adult, if you're in the age of majority and you enter into a contract with a minor, someone below the age of majority, that adult doesn't have the luxury of voidability. That power only rests with the minor. So the adult is sort of stuck with the consequences and the decisions. So every rule has its exceptions, right? And the Doctrine of Necessities is an age-old exception to a minor's ability to contract with someone. And the Doctrine of Necessities basically says that if a minor contracts for something like food, shelter, clothes, or medical care, something that is an absolute necessity, then the minor and or the minor's parent will be responsible for the reasonable value of those services. So the person on the other side of the contract from the minor is not going to be allowed to charge exorbitant fees for something that's a necessity. The court's going to look at what a reasonable and standard customary charge is for that particular thing and then apply that reasonable value. And that's what the parent would be responsible for in this case. The more difficult question here is, what is a necessity? Just because something is food doesn't mean it's a necessity. Just because something is an apartment doesn't mean it's a necessity. You can imagine a minor signing a lease for $1 million apartment on the edge of Central Park in New York City. That's not a necessity. Shelter is a necessity, but not $1 million apartment. So the courts are going to look at necessity on a case-by-case basis. And in some cases, something like a boat wouldn't be a necessity, but if you live on an island and the only way to get back and forth to get food is with a boat, then in that case, a boat is a necessity. So the courts are going to look very closely at the facts of the case and the relative positions of the minor and the parents. There's a famous case, Young versus Weaver, that I think you should take a look at, and it essentially deals with this definition of necessity. The facts of the case are basically that a minor signed a lease with a landlord. And the lease was obviously for an apartment, which is shelter. The reason the court said that that shelter was not a necessity is that this minor still could live with her parents if she wanted to. So it wasn't necessary for her to live in this apartment, therefore the apartment wasn't a necessity. If the minor had no parents, had no home, had no family to live with, then they need somewhere to live, and signing that lease might apply the doctrine of necessity. So you can see the difference there. Another issue we deal with a lot in contracts dealing with minors is minors that misrepresent their age. We've all seen 15-year-olds that look like 20-year-olds, and some people use fake identification to misrepresent their age. So what do we do with that? Well, it's important to understand that the law still places a heavy burden on the adult in the situation. So just because someone had a fake ID or just because someone looked like they were older doesn't mean that the adult is out of trouble, so to speak, in this issue. The court's going to look very closely at the facts. If it is determined that the adult reasonably relied on a misrepresentation of age, the weight changes just a little bit. Remember, ordinarily an adult cannot disaffirm a contract made with a minor, but if there is some valid misrepresentation, then the law is not going to require the unsuspecting party, the adult in this situation, to go through with the contract. But to even the rules out, if the adult in this case voids the contract, the minor will be required to return the subject of the contract. Say they bought a car, the contract for the car is canceled, the car has to be returned. The tendency, though, is still to lean very heavily towards the minor. So if we have the situation where there was a misrepresentation of age, the minor takes a car, again, let's say, drives it around and damages it, the law will still allow that minor to bring the car back and return it and disaffirm the contract. So the onus is really on the adult to make sure that the person they're dealing with is of age of majority. Okay, so you should understand that contracts made by minors are voidable by the minor in most cases. But what happens when a minor enters into a contract prior to the age of reaching majority and then they keep the subject property and reach the age of majority? Does it automatically become an enforceable contract? Well, the answer is no, it doesn't automatically. What has to happen is that the minor will have to ratify the contract in some way. And after they reach the age of majority, if they continue to make payments on a car that they bought when they were a minor, for instance, if they continue to use the car once they reach the age of majority, then that contract is going to be considered ratified. They can also ratify it by positively going and say, I ratify this contract. If, however, they reach the age of majority and they want to disaffirm, they can do so within a reasonable time. So they can ratify through actions or an express ratification that can be either oral or written. Again, a contract made while you're a minor doesn't automatically become valid once you reach the age of majority. Ratification has to occur at that point. Okay, one final issue with regards to minors. We have something called the emancipation of a minor, which is a minor that no longer lives with their parents. They live separately and apart from their parents. They're on their own, so to speak. If the emancipation has come through a judicial declaration, or the minor is married, pregnant, or some other acts that are specified in your state law, then that minor may have the ability to sign a valid contract. So emancipated minors usually have the ability to enter into valid contracts, that they don't have that power of voidability. There's a really good chart Exhibit 6.2 in your book. Take a look at that. That'll help to condense everything we've just talked about. Let's take a look at some other individuals who may lack capacity to enter into a contract. People like those that have been declared insane or have mental illnesses, or the people that are intoxicated or drugged, that lack the requisite capacity to enter into a binding contract. The law makes distinctions as to a person's capacity based on the degree of mental inability. So suppose that an individual's mental ability is impaired only temporarily in the case of somebody being intoxicated. That situation is going to be treated differently than someone who is long-term mentally ill, or someone who's been declared insane or declared to have a lack of capacity by a court, which would be ongoing. Determining whether a contract made by one of these types of people is voidable or void or enforceable is a difficult task, and each situation is evaluated independently on a fact-specific case-by-case basis. So you're really going to have to dig into the facts of your case in order to try to figure out what type of contract you have. Let's deal with void contracts first. If someone has been judicially declared insane, or what we call non compos mentis, they lose the right to contract. In other words, the court has said this person lacks the capacity to enter into a contract. We're not going to hold them to anything. So they can't make contracts, and that if you can't make a contract, that means if you try to, it's void on its face. They can have guardians who are mentally competent enter into contracts on their behalf, which would be enforceable. But if the party themselves, the one who's been declared judicially incompetent, tries to enter into a contract, they can't. It's void on its face. Now, if a person is undergoing some type of mental illness but they haven't been judicially declared insane, it depends on when they try to enter into a contract. If they try to enter into a contract during a period when they're having the mental problems, they lack the capacity. However, if they enter into the contract during a period of lucidity, when they're not affected by the mental illness, that the contract may be valid at this point. And to avoid the contract or to disaffirm this voidable contract, the party will have to prove that at the time they entered into the contract or tried to enter into the contract, they were undergoing the effects of their illness. If they can't prove that, then the contract is going to be enforceable. So a mentally ill person is going to create a voidable contract if they are incompetent or insane at the time of the contracting, but they haven't yet been declared judicially insane or judicially incompetent. Along those same lines, where we have a temporary lack of capacity, are people who are drunk or intoxicated or on drugs. And what determines capacity is their degree of intoxication. In other words, the degree of reduction in their capacity to understand what they're doing. If they are so intoxicated or so drugged that they couldn't understand the nature of the contract, then the contract is voidable. But it's going to be the burden of the person trying to disaffirm the contract to prove that they couldn't understand. And the court's going to use that objective standard where they stand back and look at the acts and the words that the person used to try to figure out whether or not that party knew what they were doing at the time. So if the person is able to prove that they were intoxicated to the point where they couldn't understand what they were doing, once they become sober, they can either disaffirm or they can ratify the contract. So if it's a voidable contract that's created, if they are so intoxicated they can't understand. And when they become sober and they regain that capacity, they can decide whether they want to ratify the contract, go through with its terms, or disaffirm the contract and walk away. Okay, two more groups of people I want to talk about. The first is aliens from outside of the country. As a general rule, just because you're not a citizen of this country doesn't mean that you can't enter into a contract in this country. The only exception to that rule is if we happen to be at war with the country from which the alien came, there may be a declared lack of capacity to do business with somebody, someone from an enemy country. Okay, final group I want to talk about is convicted felons. Essentially, whether or not convicted felons have the capacity to enter into a contract depends on where they are. Usually, contracts made by prisoners that are currently in prison, in jail, are void on their face and unenforceable. But when they are released from custody, they regain the right to enter into contracts. So it has a lot to do with whether or not they're in jail or in prison or out of prison and they have been released. Exhibit 6-3 in your book is a great chart that explains all this in a graphic nature. I commend that to you. In summary, parties must have the capacity to enter into contract in order to create a valid and enforceable contract. To have capacity, a person has to be over the legal age in their state and be of sound mind. People who lack capacity create either a void or avoidable contract. Some of the folks we've talked about are minors who lack the capacity to contract. They create voidable contracts. People who are mentally incapacitated create either void or voidable contracts, depending on whether or not they've been declared judicially insane, or they're just having some mental issues that sometimes reduce their mental capacity. Individuals who are drugged or intoxicated may lack mental capacity if the drugs or the alcohol reduces their ability to understand what they're doing. Generally, aliens have the ability to contract, and convicted felons lack the capacity while they're in prison, regain it when they leave prison. That's all we have this week. As always, if you have any questions, don't hesitate to contact me. Hope you have a great week. Take care.